Hey everybody, it's Tracy, and I had fielded a few questions online recently about Polymarket and what happened. And if you aren't familiar with the story, Polymarket was offering a prediction-based crypto price platform. So just like binary options, you could go on and effectively place a investment or bet, whatever you want to call it, as to certain price fluctuations, whether it be a particular crypto or an indice or volume, what have you. And the CFTC sued them under the guise that they were not registered as a direct contract merchant, right? And the background is this, right? With any futures, whether it's oil or crypto or anything like that, you need a buyer and a seller. Like, so you can have unlimited numbers of contracts for a commodity, provided there's enough of the commodity, as long as there's a buyer and a seller, right? That's how you create volume. Whereas like in a token sale, there's a limitation because there's a max supply. So in making these contracts or facilitating these, that's when the CFTC came in and said, Polymarket, you can't do this. And there's three layers of regulation, right? And it's a very, very gray area. One, you have the CFTC with ultimate control, and they have this blanket, power dating back to FDR to basically regulate anything that's not in the public interest. So the CFTC's position has long been that the prediction markets constitute gaming, right? Because it's not in the public interest and therefore should be banned absent like a registration. So you see like Predicted, which is an exception because they got a non-action letter, which has since been revoked, and they got through because they were operating as a non-for-profit through the University of Iowa. And the concept is basically like they wanted to do prediction markets on like the outcome of elections and things like that, right? And so that's where the CFTC has long held on to this gaming. And it's this kind of, the commissioners of the CFTC, I believe there's 5, can kind of just say and do what they want, right? It's not like an act of Congress. On top of that, you have the Unlawful Internet Gambling Act, which I've talked about before, which basically prohibits financial transactions to and from online gaming operations, which in the past, right, has been used to enforce like offshore casinos from soliciting U.S. customers and carries with it significant criminal penalties. And that has kept a lot of prediction markets out of the arena. At the same time, the act has an exception for daily fantasy. So when you look at it and you say, all right, game of chance, game of skill, right? Game of skill being like daily fantasy. Is there a way to like reverse engineer a prediction market so it looks and appears to be more of a game of skill versus a game of chance? And I think there are ways, right? They're untested, and I think you're perhaps best, trying to get a no action letter, which can take a long time. But it is definitely, advisable, right? Because I think that's where the Unlawful Internet Gaming Act sort of gives you that in for a prediction market. And it's going to depend on what types of products or events that you're actually making predictions on. And then on top of that, you have the Dodd-Frank Act, which seemingly regulates every facet of our lives. And that basically said specifically that there can be no futures contracts related to anything contrary to public policy, which has included everything ranging from assassinations to, again, outcomes of elections. So you have this like morass, right? And at the top is the CFTC, and it's very at their whim, right? And, you can register, as Kalshi has, which is now being questioned, as a direct contract merchant and operate, but that's an arduous process. So the question becomes, is there a legal safe harbor for operating as a game of skill, which I believe there is, right? I think it's very tenuous because people don't want to try to do it, right? For fear of reprisal and be like the first mover. But when you look at, and I always harken back to daily fantasy because it's specifically been sort of passed upon and deemed legal, subject to regulation in the states, obviously. But there is means with which you can make that argument, but I don't think anybody wants to get tied up in court having to make that argument against the CFTC or whoever else. So it's an interesting thing. And then obviously like offshore, like crypto or DeFi, you harken back to like the same arguments in the DeFi context. You say, well, we're sort of the headless horse argument, which we see, and I've talked about here before, kind of falling apart. And then you also have just the extra jurisdictional concept of like, hey, we're offshore, we don't care. Now, US law would always apply, but the rest of the world would largely be in play, and the rest of the world treats prediction markets quite differently. And to some extent, it's almost a binary option, right? Which is, I've talked about that as well. It's kind of much maligned, but you have this ongoing debate whether you need a gaming license or a financial, like a Forex type license to operate those platforms offshore. And, I think gaming it's definitely easier to get those licenses, and you can operate more freely and lower costs and those things. So in any event, if you have any questions on prediction markets and how those can be structured and look, definitely hit me up, Adam@adamtracy.io, and I'll talk to you next time. Cheers.